Great. Well, thanks everybody. It's so good to be with you. So the personal liability of chief information security officers has really, we all know, become a stock topic at cyber conferences where they gather, where their lawyers gather, where their security advisors gather. Very hot topic, even in incident response. So we thought we would do a topical exploration of kind of how we got here and where do we think we're going. Our first topic, I guess, sort of ripped from the headlines, as they say, is a bit of an update on the SolarWinds case and what we should all be taking away from the, the initiation and ultimate resolution of the SEC's investigation and litigation against SolarWinds and Tim Brown, its chief information security officer. So I'm sure everyone will remember this followed from the 2020 Sunburst attack on SolarWinds and their, product, and that the SEC went after them for, supposedly, allegedly concealing red flags. Initially, the motion to dismiss that pleading had pretty significant success in front of Judge Paul Engelmeyer, who limited much of the SEC's theory of the case, and then discovery went on and into actually exactly what was their cybersecurity program, what exactly were the representations, and how much of the SEC's theory that remained could survive the facts in the case. I think for CISOs, the stakes really are broader than, and our panel wants to think about pitfalls for CISOs more broadly than just the literal stakes before the SEC that you could result in financial penalties or injunctive relief and corrective actions and the things that administratively, an independent agency like the SEC can do. It certainly has a significant, personal life and reputational impact, whether the allegations are meritorious or, I think as they proved here, without strong evidence. Just the allegation that you were part personally of something where investors were misled and that's going to be investigated for 2 years at great personal stress and be in the public domain and be the topic of all these conferences for 2 years is quite, significant, because people are going to be wondering, were basic security practices adhered to, and it can certainly be, be very, damaging. And so we want to think about pitfalls in a broader way than simply, what might the technical legal outcomes be. So I think that leading up to the announced dismissal of the case, you saw a lot of arguments back and forth, including with huge contribution of a lot of amicus briefs, that what is the role of the SEC? Does it have some kind of general police power around cybersecurity, failures, and how is cyber risk allowed to be talked about within, a company? And we don't want to chill internal conversation about risk. At the same time, obviously, affirmative misstatements are always and forever going to be, that's a doctrine that's not been undermined in any way, that you can't, do that. And so, with the kind of principled stand that company and its CISO chose to take, kind of throwing their faith to the courts to sort it out. I think when all the discovery and the dust settled, that the evidence fell pretty short of the original theories and allegations of the case. But let me throw that immediately out to, Ed, I know you have some awareness and involvement. I would be super interested in what you think the implications are. And then, of course, we're going to, turn to Phyllis.
Sure. And my involvement was representing the CEO of SolarWinds, so we were pretty close to the whole situation. What was concerning to me was that the statements that the SEC pursued against Tim Brown were statements on the web where he was talking about SolarWinds security. A lot of companies have blogs are just statements about security that they put up to avoid having to constantly answer questions from clients about, are you SOC certified? Do you have an ISO certification? Are you SOC certified? all those kind of basic system questions. And it was really a question of putting that sort of communication, I think, is extremely helpful and routine. And then looking at that after a breach and saying, well, you said you had good access controls, or you said you had this, but it turns out that might not have been entirely accurate in light of the breach. That kind of retrospective second guessing was exactly what the court threw out in the Southern District of New York. And, you know, the statements were kind of true when made, and turns out were actually true upon examination, even after the fact. But the amount of chilling effect that would have, if you have to have every time a CISO wants to put a statement about security up on their blog or on their website, it's got to go through legal review. All of a sudden, it's going to be watered down. It's not going to be as helpful, and it's going to diminish the ability for CISOs and others in security to speak to each other about security. And particularly as the SEC is now, with their new Reg SP, ramping up this idea of vendor oversight and third-party liability, how can you? It seems counterproductive for that sort of discussion.
Phyllis, so what implications do you want to comment on for now that the case is fully resolved?
Well, and of course, our firm was involved in assisting on the representation of Tim Brown, and he actually has been quite fantastic in sharing his experience with his colleagues. And as you know, there were great personal sacrifices and health issues associated with him going through that rough storm. But the company and Tim, like you said, stood together and worked through the process towards this important and appropriate resolution. I'll say more broadly, Jennifer, that I think where we've gone with CISOs is moving away from a technical position and really into a complex leadership role. Mm-hmm. And it is, and I agree with you, Ed, that legal can't oversee everything the CISO says, but I think it is important that the view of the CISO is incorporated from an enterprise perspective and a leadership perspective. And there are appropriate times for the CISOs to use legal as their best friend, in particularly in the context of a security incident, as opposed to the day-to-day operations, which would be impossible. So in that way, I think where we're moving is away from CISOs thinking only as being technical advisors and leaders to enterprise leaders, and it's no longer the time to go it alone and to stiff arm legal or others in the organization who are working towards understanding what the CISO is doing. And I know we're going to talk a little bit about reporting and coordination in a bit, but I think that that's going to be really important for CISOs to have an appropriate reporting structure that will help mitigate risk to the organization and also to them personally.
Anything anyone else wants to add before, and if there's audience, particular questions about, SolarWinds, we're happy to try to weave those in. But I think, some of the implications for me are that the SEC is one, enforcement and liability, risk and path. Mm-hmm. It's one of many that might hinge on affirmative misstatements and the need for well investigated, truthful statements and a number of things at the right time. But I think that there's a lot of other sources of law that, maybe even in a ransomware in particular, might create personal exposure for a CISO. Let me call on you, Daron, and say, I know you've had some recent experience with state financial regulators and how, you think the role of the CISO, came into play, and some insights you might have coming
Okay.
from a different administrative regime.
Yeah, I think on the heels of the dismissal of the SolarWinds case, I think we're right to suggest that public statements with verified technical realities or bound by those realities and the like are still subject to scrutiny, not just by the SEC but others. And yes, the multi-state process, especially in the financial arena, where states get together and seek to get remedy against a financial entity for, in this case, PII exposure and customer risk and the like, and that multi-state enforcement action and eventual settlement resulted in more than $50 million for the company to pay. And during the process, the pre-incident cybersecurity program was scrutinized heavily, as was the response. And during those various aspects of the review, individual roles were looked at, specifically the CISO and other leadership. And as we were working through that, it kind of timely that we're talking about liability and specifically personal liability, because there was a lot of questions about what individuals did, what they knew, and how they made decisions and the like. I think the results are not just examples that we see in the SolarWinds issue, or Uber. I think is another example of senior leaders in a organization being held accountable for, in Uber's case, a cover-up. But certainly some good examples out there that sort of demonstrate the need to still make sure that public disclosures and the like are truthful, factual, based on verifiable evidence, so to speak.
Phyllis, are we still seeing, we obviously, like all of us who are privacy and cyber lawyers, have seen the role of unfair and deceptive trade practice laws at the state and federal, level is a really important thematic, entree to this world of then resulting in an order that, deeply goes into how the CISOs go about their jobs. Do you want to speak, just, kind of comment on how widely, maybe unexpectedly, UDAP laws have influenced how CISOs, go about their, duties, both in wanting to avoid that kind of an order or needing to live under an order?
Absolutely. And I think we're not going to move away from that, right? We know that the regulators are very focused on misrepresentations or omissions where consumers or others are purportedly misled based on representations made by the company. And CISOs are often involved in developing what those representations should be concerning the information security program. We're seeing the same thing with respect to privacy programs. So in that way, that's not going anywhere. And of course, once an organization has gone through the process of negotiating a consent order and then are obligated to comply with the injunctive terms, the CISO often is on the hot seat for signing off on a certification relating to the compliance of that consent order. So that's a difficult position for a CISO to be in, because oftentimes their program, the information security program, was under scrutiny, was challenged, and ultimately resulted in a consent order. And then, they continue to be on that hot seat to ensure that that's appropriately implemented. Now, of course, again, they should work hand in hand with legal. And that might sound self-serving coming from a lawyer, but I can recall years ago, and I'm sure you all can too, when you would walk into a security incident and lawyers were not always welcome in the room with the IT and security teams. A little bit of stiff arming there because it's their territory. Today, it's really important, I think, to mitigate risk for the organization and for CISOs, for the lawyers to be very involved in directing that and ensuring that we are properly reviewing risk to the organization, properly documenting that, and that there are escalation procedures in place, which also protect the CISO. If it's clear who's making the decisions about certain operations within the company as well as the incident response, then it doesn't just lay at the CISO's feet. And just like the reference to Uber with Sullivan, those were odd facts and we're also talking about a former federal prosecutor who was in that role, right? Who made decisions independently and did not share it up through the organization. It's a great example of how important it is not to take on that ownership by yourself in that context, but to ensure that you have legal's approval and that the appropriate senior leaders within the organization are involved. Then you have the circumstance where the company and the CISO are there arm in arm if they're challenged, as opposed to the finger pointing that would otherwise take place.
Yeah. So basically, matrix management is, has a role in any crisis, and this is no different. And I saw you nodding, along there. I know you have, so much experience with those kinds of investigations after a breach that do result in, a negotiated order, or that might not. But what are you thinking about the CISO and those kinds of proceedings and outcomes? What would you want to add?
The UDAP laws are it is the FTC's tool, and the state AGs that's their tool, and it's probably not a tool that one would have said was really designed to go after cybersecurity, because you have this situation where there's no specific requirement dictated to an organization, and it's just avoid misleading statements. People are like, okay, fine, but then you can mislead by omission, and I'll say, so there's a secret, we'll let you know later. These are all the material facts you have to disclose, and you wind up with this very common law approach to regulating cybersecurity, which is a very odd, it's a very odd thing to do, to have such a technical area be regulated in this common law manner. And we wound up there just because that's the statutes that were given. But I think we'd have a much better dialogue between the lawyers and the computer scientists if we had specific undertakings and said, okay, we want you to have these controls in place, sort of like NYDFS does, or the Massachusetts Information Security Regulation, where you said, here's what we mean by negligence. If you have these, you are reasonable in your conduct. If you don't have these, you might be negligent. But instead, most of these broad cases are being brought under these amorphous laws of, unfair, deceptive. And the SEC now is, bringing it under a standard where it is a very amorphous standard of, material omission or a false statement, which is, I think, very difficult for someone who doesn't have a legal background to get their arms around. I mean, the lawyers love the ambiguity and all that, but the technologists do not.
Yeah. So Phyllis, there's the, statements made on the occasion of a breach, which lawyers generally are pretty well embedded and can control. Is there any tip, Ed, you'd give for, CISOs who are running a security program? They think according to the reasonable, measures they should have in place, that can kind of mitigate the gotcha of a misleading omission or something, like going into, like if we assume that breaches can happen, what kind of a program, what kind of tips in running the program itself?
Well, in the context of a security incident, I think we need to be careful not to operate in silos. And think that's where we get into issues of inadequate communications through the organization, so that one group doesn't fully understand what the other group is doing. And of course, the CISO is right there in the middle of the fact development. And if the CISO is not engaged with those who are developing messaging and confirming the accuracy of it, that is a tough spot for the company to be in. I think it's important for CISOs to be open to bringing in third parties to validate, so that their own team is not the one basically defending what they did or didn't do and what happened in the scope of it. I do still see that repeatedly when we come in and there's a resistance to bringing in a third party directed by legal, as opposed to someone who's already embedded with IT and security who would be the one to investigate. And of course, there are some significant privilege issues associated with that. I do recommend to CISOs that they have training on the privilege so that they understand it and the implications of operating independent of legal in advance of a security incident, so that we're not training them in the middle of it. I also recommend that they have a basic understanding of the law in this space, so that at least at a high level, and we know they're not lawyers, but at a high level, they should understand some of the obligations, contractual, notice obligations, and professional responsibility obligations if they're with an organization along those lines. And then going back to my earlier comment about their leadership role, they need to understand how to report up. And Meredith Griffanti, I think, referenced this in one of the earlier panels today. I think it's critical that CISOs understand how to report to senior leadership, and that they have appropriate reporting into boards, because that also makes sure that the risk is appropriately delivered to the highest level within the organization, and there's transparency. They're not overly concerned about showing a risk because they're responsible for it, but that they are transparent at an appropriate level with senior leadership and the board.
So clearly, like board level, how to do board level risk briefings, just having, decision makers be, what do we want to say, fluent and comfortable with, able to understand what kind of risks are being accepted, as decision makers. And that someone's out there, I guess, picking up something, as you said early on, is that you need accuracy reviews of your public, messaging, whether it's like a SolarWinds about your product or, simply, about that. What in that realm, Ed, what would you say are some of the lessons, learned, there that, around just their communication skills? Because I'm sure, they started from technical advisors, right? And now we're suddenly talking about, they need to think like a CFO, and thinking about risk. What are some practical or, insights you want to share there, Ed?
So,
I think,
I'm sorry.
go ahead.
Go ahead, Daron. Yeah,
I thought you said Daron. Apologies for that. But this whole discussion reminds me of a CISO we work with often, who is technically, and you brought this up, as CISOs sometimes evolve from the technical world into leadership roles. But this one is very technically qualified. In fact, often the most qualified responder at the table, even with outside breach counsel and forensics firms. And he or she actually has and is coached by outside counsel in roles like, and I think it was mentioned before about, the CISO doesn't want to be the one making unilateral decisions or in an investigation, observations based on only their, only their technical abilities and the like. The outside counsel that we worked with often with that CISO really works to guide and focus on roles. And I guess to answer your question, it's as a CISO, it is ideal to to sort of embrace the idea that they are overseeing the technical side of an incident, that their role is to make sure all the players, the SOC, the incident response teams, the external forensics provider are providing factual data and their investigations, and confirm those findings, validate those findings in some way, so that when the information is passed up to decision makers, that those are grounded in fact. And then also as the issue transitions into containment, that containment is it takes a village. I think it was mentioned before that I think Phyllis, you've been foot stomping this, that these sorts of decisions, whether it's response actions or containment, cannot be made in a vacuum by a CISO. And we see that as responders, in some cases we do post-incident expert services work where that sort of mindset to make these decisions more of a village than unilateral effort. Outcomes are more positive when they aren't unilateral, and so the idea that information that goes up and out being factual and based and validated is key, and so owning those roles effectively are a good way to make sure that the investigation stays on track and we don't get derailed after with some of these fact gaps.
And if I can just add one thing to that, Jennifer, because I agree with what you said, and to the extent that a CISO needs to make an independent decision, then there should be clear authority to do it. So, for example, if they need to take systems down or, take things offline in order to, and we're talking about in the context of ransomware in particular, they should have the power, and it should be clear that they have the power to make those decisions. But otherwise, when they are working on the scope of the incident and recovery and remediation, what systems to bring online, the impact to the organization from an operational perspective, now we're moving up. Now those decisions shouldn't rest at the CISO level. There should be input from the CISO. But that should come up to a broader group, a leadership group that ultimately can evaluate the risk to the organization relating to that ransomware attack. And
that's exactly where I wanted to go. Next is what's unique about a ransomware attack is simply the extortion, but that often is going with some level of operational disruption and maybe exfil. Exfil presents a lot like other data breaches, but the operational disruption really is unique. And so wonder if Ed, if you wanted to jump in there as well on, the unique decision, making, challenges. And a lot of it, I suppose, comes to readiness, like how much have you rehearsed for that, kind of a circumstance. But can you just comment on the role of a CISO that's unique to the disruption that can come from a ransomware threat?
And I was going to say one of the best things about the way things played out is I think one of the lessons coming out of SolarWinds is the integrity matters, and the fact that you have someone who if you've got someone who's being straightforward and saying things that they believe to be true, they can stand their ground and fight. And one of the things that I think that going to ransomware, the important thing there is to actually tabletop it, do the exercises with the technical team, but also with the executives and the board members. Because I think sometimes in the ransomware context, where people sometimes they don't want to message that there's been a ransomware attack, and they talk about a security incident, and they say, well, it will sound better this way, or an incident or an anomaly in the system. It starts feeling like the lawyers are pushing away from speaking clearly and with integrity, and that's important to have a working relationship between the CISO and the attorneys and the CEO and the board members who are going to be making that call about how are we going to talk about this externally, so that there is this understanding and there is a mutual confidence in the integrity of the other players. I think it's very dangerous for a CISO if they think the lawyers are going to spin something beyond there's shading things, and then there's changing the color entirely. And sometimes lawyers, in their quest to protect the company, will step too far in that realm. And I think it's important for the CISO to work with the lawyers to get them to recognize that, yeah, you'll get through this ransomware attack. There'll be light on the other end of the tunnel. And it's most important that you maintain your client trust and your customer trust. And so better to speak honestly than to, sound somewhat better in your one news cycle than when it first pops off.
I think the worst situation for a CISO in a, an operational disruption type of a thing is that, just the blast that they're getting constantly of like, when are we going back? When are we getting back to normal? When are we getting back to normal? And that damage assessment takes time, but it's also a big test of how well did you prepare, right? Like how many layers of redundancy did you have built in operationally? What kinds of backups and recovery? And so I think this is what I see, is a lot of stress comes from not particularly having rehearsed what those challenges to continuity and getting back online and already will be, because they could overpromise you can overpromise with integrity. So like have the most sincere purpose. Let me sift. I see a couple of questions, coming in, but let me thinking about, CISOs. At what point do they need their own lawyer or their own insurance, or they need to don't even take the job unless you're in the D&O policy, or you got to have the indemnification. Les, I think that would kind of be at the top of their list of my worries and things that they feel like maybe lawyers could help them understand. So and maybe I'll just do a round robin on that. And maybe I'll start with you, Daron, and, ideas you have, but you give everybody a shot.
Sure. And it should be obvious by now, I'm not coming at this as a legal professional, but I often do sit with CISOs at the table when there's an incident and, or there's some regulatory inquiry. And, as we prepared for this panel, I reached out to 5 of my CISO friends, and it was kind of an interesting discussion because a couple of them really hadn't considered, liability and coverage, and whether or not, they should consider whether their personal liability was such that it warranted, legal advice and the like, and how that departed from, the directors and officers liability insurance that their company may or may not have. And in one case, the CISO was very confident that they were covered, and in a couple of others, they had to go check. But one of the CISOs I talked to,
which is a lesson in itself, isn't it? Right.
Right. And one of the CISOs I talked to was also they just come on the other side of a merger and acquisition. And it was kind of a timely conversation for him, because he really hadn't thought to, in this new context, look into liability and whatnot, and whether or not the coverage that the company offered was sufficient. They hadn't had that discussion yet.
And I guess it could be defense costs as much as anything, right? Like I kind of, shy away from that word liability, because there really aren't very many
Yeah.
I mean, I think Sullivan got some, like he has to make financial amends or something, but it's usually not about paying to damages to injured persons.
Mhm.
But the entanglement with a legal investigation, if you're not being indemnified by your employer, could be pretty substantial.
Right. And I think the eye-opening thing for me is how much discussion we probably need to have in this realm to get the CISOs to sort of reconsider their position and their whether there's risk there or not, and the like. But sparked some really cool conversations that maybe in the end the result could be to recommend that CISOs and lawyers that work with them, maybe ask them that same question.
What do you think, Ed?
The thing that worries me is all these certifications that CISOs are having to sign these days, particularly on government contracts.
Right.
Because of the potential False Claims Act exposure, or in the healthcare context, if there's billing to the government, you have that kind of personal liability that can come up from making a false certification, or even under NYDFS, where you do the certifications. I think it's going to be important for the CISOs to keep good records of when they are certifying and the basis of their certifications, and it'll be difficult to maintain good records and feel comfortable with that at the same time as advocating internally for more budget and more headcount, because things are broken and they need to be fixed. And then the next week you have to certify that everything's been fixed when you still have the budget to fix it. That is a real difficult issue. And I think it's the kind of thing where if there's you probably don't need separate counsel for that in the normal course. But I think during a data breach, if there's a breach that really starts picking up, I think it's very wise for the officers to start getting separate counsel pretty early on. But I would think they would want to work with the company so that their choice of outside counsel is someone that the company is comfortable working with, so that people can continue. It's not seen as kind of going off on their own, because CISO as whistleblower is a real fear, I think, in a lot of C-suites. And so if you select your own counsel and the company is not comfortable with that, they could easily start worrying that, wait, can he stay
What
inside
reservation
the tent?
are you on right now?
Yeah.
I think that the Department of Defense or just other government programs really tee that whistleblower, concern up. Phyllis, what would you like to, add about whether, personal counsel, indemnifications, and, insurance, things like it, it feels like a standby. Yeah, I just think they should have an approach and an attitude about, way to approach it. Maybe it's not needed in every case, right? But, what would you like to add?
And I think it's probably not needed in many cases, because when you think about the number of security incidents that we handle, the vast majority wouldn't require independent counsel. I do think it's important that they think about these issues in advance of a security incident and that they talk to someone about it. And, oftentimes when I see there is the need for personal counsel, all of a sudden they're calling up their uncle's friend who has no experience in this space. So if they're going to go for counsel, they should definitely look for experienced counsel in this space. They should consider insurance. They may not qualify for D&O insurance. It depends on what their position is. Obviously, when you're negotiating a position, is the best time to talk through some of these things with the organization and understand the company's position. Just like you said, the defense costs. Some organizations will front defense costs, at least up to a certain point, because that can get quite expensive. But, to the earlier discussion about the CISOs who hadn't thought about it, it's never too late. And what I always encourage them, if you didn't talk about it when you were hired, maybe you have a friend in the legal department there that you can go and broach the topic with and just express some of your questions. It's appropriate because, like you said, it may not be that the risk of liability is that high, but there is risk that they will be scrutinized, that they could become the target of an investigation. And because regulators often do look at individuals within the organization and not just the company.
Go ahead,
I
Ed.
would just go back to the Yahoo incident as the kind of circumstance where you'd want to have separate counsel, because there you had the information security team reach a certain view, and the lawyers did not share that view, resulting in a lot of angst internally. And that sort of disconnect, that I think is something where the CISO should, even if they have to do it on their own dime, think about their own potential exposure. If the CISO believes that there was a breach and the lawyers aren't convinced, that sort of exposure, I think it's very touchy, and for the CISO.
I mean, I think that you brought up the integrity point, right? That, if you approach your job with integrity and you feel you're in a position anywhere, then, it doesn't hurt to get, an independent look on that. Bruce is going to pop in here any second and tell us we have a minute left. So anybody, a year from now, do you think we'll be doing the CISO personal liability panel, or you think with SolarWinds behind us, and, these other things, like what's perennial about our topic, looking, if you were to flash forward for, where we think the trend is going for, CISOs getting entangled with the law?
I think we'll still be talking about similar topics, maybe not for the same motivation, but reputational risks is still an issue. And disclosing accurately and as fulsome as possible is still going to be, I think, enduring. And so maybe next year this will be called, maybe something else, but, there's some lessons to be learned from, I think, SolarWinds and others that, transcend, regulators. It's good business to learn from, in my opinion, what was being scrutinized during, these sorts of regulatory inquiries, and then apply those learnings to business practices.
I think we'll still be talking about it, Jennifer, and we'll see too. Of course, CISOs have lost their jobs as a result of cybersecurity incidents. So even if we're not dealing with some of the same regulatory scrutiny with them, I think to a certain degree we will. The UDAP laws aren't going anywhere. So they'll still be in the hot seat for some time, I think, and they need appropriate guidance in order to mitigate their own personal risk.
Yeah, I agree with that we're gonna continue to see this, particularly as so many more regulations want personal certifications. They want someone to sign on the dotted line to certify this is true. Those certifications are real danger points, particularly if there's a breach and then the regulator decides to look retrospectively back, as they tried to do with SolarWinds, and say, what should you have known when you certified that, even if, in fact, it was unknown.
So we'll be back next year, Bruce. You just got to ask.
Any last thoughts from you, Jennifer?
No, just it was, terrific to have everybody, together, and the people who are so, grounded to live and, really working alongside CISOs every single day. So I thank everybody for their time.
And thank you, Jennifer, for doing a great job moderating. And to the panel, Daron, Phyllis, Ed, thank you guys so much for all of your thoughts and your insights today. That's it. That's the last panel for the day. I want to thank the 20 world-class law firms and consulting firms that participated in today's event. And I want to thank all of you for being with us today for this virtual event. I hope we'll see you again soon. But that's it, and take care.